Hi, everybody. Welcome back to Crafting and Crime Daily. I'm Rebecca, your hostess, and today we're going to sit and listen to the Sarah Boone closing arguments. So let me pull those up. We'll go to the courtroom now. We've got a little time, I think. I think. We are still on the seal, so we're good. But we can sit and we can chit chat. Until then, I have a new hi, Sarah. I'm trying out a new thing here. Here we go. There we go. What do you think? Me and the little round thing? I'm playing. It's a new feature on StreamYard. You can put a round thing instead of a square. Sorry, I'm texting. It's been a crazy morning. I'm texting with Leopard Leatherworks about a January event. Are you feeling better today? Not as tired. I'm rested. I got a good night's sleep. My sister is all tucked in a bed that's not in the emergency room. It's actually in the cancer center floor, which I feel happy about. Um, we had a little tussle with the emergency room last night about getting her situated, but they're giving her blood, and she seems to be holding her own for now. So, how you doing, Sarah? I was actually texting Carrie with Leopard Leatherworks. Um, I was gonna be doing a Richard Lorenz event in November. I'm moving that to January. That's with Color and Chat with Joanna, and it just works out better for both of us if it's in January. She's not out of the hospital. She's still in the hospital, but not in the ER. She's in what they call it's just a floor in the hospital that they call the cancer center. So yeah, pick out a Richard Lorenz painting for January. But next year I'm doing the Year of Christmas all year long. So in January I'll be doing Myrtle, the Richard Lorenz Christmas. Myrtle has all the decorations on her. It's kind of a fun painting. Um, I'm, I don't know which painting Joanna's doing, but Joanna has to have surgery, so it just worked out better for both of us to move it to January. So we're still got the seal. Yeah, she has a room away from the ER, all the hustle and bustle. She was literally sitting in this dark room with nobody checking on her, nobody doing anything, and her nurse was like a wreck. I had her on the phone. She starts crying. I'm like, "Oh my god, what is going on in this emergency room?" Um, I think she said she had 23 patients. That's insane. I was a nurse. 23 ER patients is just ridiculous. I'd probably cry too if I had that many patients. So, but on the cancer floor, the doctors know her, the nurses know her, so I think she's way more comfortable on the cancer floor. So, I will be texting and, doing I'll have the mic muted during the closings, but I am pretty excited to hear how the prosecution is what was their thought process in showing the body cam footage and the videos that I posted this morning. um, and I wanna see if I'm on the mark, d is it to show her control over him? Because I certainly think that's what I was seeing. Um, Jury instructions and closing arguments. Now he's gonna read through the jury instructions, and that usually takes half hour, so it's I think he said 34 pages. He says he's never timed himself, but, once he reads the jury instructions and then we hear the closings, it's gonna be about 5 o'clock ish Eastern time before that all wraps up. Then it will probably go into, it'll get to the jury. They can stay in the courthouse till 9, without permission, but the judge said he was gonna get permission for them to stay later. So, they may deliberate as long as they want tonight. I don't think they're gonna reach a decision tonight, to be honest with you. If they're gonna start going through all of that evidence, just the text messages were 108 pages. They didn't read them all, they just read certain ones, but the entirety of the 108 pages of text is going back to the jury. I know if I was a juror, I'd probably wanna sit and read it. So, okay. "You being a good girl, Dootie." I think she misses my sister. Okay. And we're waiting and waiting, and nothing ever starts on time with these cases. If you I know you watched this morning, Sarah, so I am gonna catch you guys up on the Delphi stuff this weekend. I just didn't have time to do it yet. There's only so much time in the day, and, I'll get to it. I promise. Because 'cause I'm as interested as everybody else in this Delphi case. Oh my gosh, I got my, diamond painting drills this morning, you guys. I ordered from them. I ordered their, package that's available this month, all the fairy dust drills. Oh my god, you guys. I'll show them to you later. Do you plan to cover the case in Washington State about the 15-year-old who murdered her family? Sure. I will cover that. I didn't know anything about it, but, I'll look that up and I'll cover it. Is that, like, the next trial that's gonna start? It sounds interesting. I don't like to cover cases involving children necessarily, but, the victim is the family, not the 15-year-old, so I'm always interested in what makes children commit these crimes. If you could, and you don't mind, Sarah, do you know the name of the case or where where I could look it up? Okay, that's probably enough information for me to find it. I'm just answering. I think I'm getting busy enough that I need an email just for my YouTube. I really do. You're interested in the motive as well. Yeah. Falls City, Washington. He just he just got charged yesterday, only living family member of his younger sister. Oh, it just happened. Oh, that's why I haven't heard about it. Definitely. a lot is gonna depend on, 1, are they gonna charge this 15-year-old as an adult? I suspect that they will, um, and then we'll see if there's going to be a trial. I can't type. I'm a terrible typer. I love when these kids sit there with their phones like this. I'm like doing this and typing the wrong thing. I'm so not that generation. What's taking them so long? They're charging him with 3 c oh, it's a guy. Okay, it's a male. 3 counts of aggravated murder, 1 count of attempted aggravated so one of them survived. The younger sister. Oh, how horrible. I'm glad she survived, but, oh my god. And you said 3 counts, that means his parents and someone else. I gotta look that up. Wow, this world is crazy. I'm typing 2025. Can you believe this? 20 we're we're 25 years past Y2K. Remember Y2K? Both parents and a sibling. Yeah. Oh my god, no, talk about 20 questions. I'm filling out this form. Okay. Well, invalid date. Why is that an invalid date? Hmm, that's interesting. Okay, that's done. All right, let me look this case up. You said it was in Falls City, Washington. I need to see what's going on here. Wow, mass shooting. I'm so tired of these mass shootings. It's crazy. Framed his younger brother for the murders. What? This can be interesting. Oh my God, they lived in a gorgeous home. It's a beautiful log home, you guys. Wow. This says 3 juveniles, 2 adults killed. What? 1 hour ago. So let's see what the USA says 1 hour ago. 2 parents slain in a shooting that left 5 people dead at a home near Seattle have been identified, and prosecutors are weighing possible charges against the 15-year-old suspected of carrying out the rampage. Mark and Sarah Humiston were identified as 2 of the victims who died, according to an employer and multiple news outlets. 3 of their children were killed in the attack. Oh my God. That's horrible. The suspect and the victims, including an 11-year-old who was injured in the shooting, are related. Officials have said the suspect and victims are related. Okay. Law enforcement responded to a home in Falls City, a leafy suburb 25 miles outside of Seattle, at about 5 a.m. God, it was just this morning. They discovered 5 people, including 2 adults, 3 young teenagers, dead. Wow. 15-year-old at the scene, and emergency personnel rushed an injured teenager to the hospital. This involved family and domestic violence. Well, duh. The 11-year-old girl injured in the shooting was released from Harborview Medical Center in Seattle. Okay, so she's released. That's good. Neighbor aided the victims before law enforcement arrived. A neighbor with some medical training managed to get to the house and administer aid before the emergency responders arrived. Oh, how sad. Suspect acted alone and no continued threats to the public. There was no significant confrontation with the young man, who was taken into custody. Wow. Hi, Tim. Welcome. How are you? My heart aches for the lives lost and those who are struggling to make sense of the loss right now. Oh my God. Um, the father worked as an electrical engineer for the Seattle-based consulting firm Hargis Engineers. Wow. We are blindsided and saddened by the tragic events. Blah, blah, blah. Yeah. Well, more to come on that case. As the teen's first appearance in juvenile court on Tuesday, a judge found probable cause for 5 counts of first-degree murder, 1 count of attempted murder. The teen will remain in custody at a juvenile detention facility until a charging decision is made by the King County Prosecutor's Office. Wow. So he's not been charged as an adult yet. We'll see. Tim, nice to see you. I was just filling out the sponsorship form for January, because you guys are my go-tos now. Did you see the I can't think straight today, I'm sorry. I did a friend mail video with the pen that, was gifted to me. The I Dream of Jeannie 2.0 pen. It's gorgeous. It's a little on the thin side for me, but I love it. I absolutely love it. I don't know that I'll do that in the future. I'm gonna do it on one more pen that I purchased because it's for my sister and she likes thin pens. Um, See, this is the one he did for I'm gonna take this out until they come in because it's obnoxious. Anyway, oh, wait a minute. Let me make myself bigger. This is the Crafting and Crime pen, which is kind of about just right for me compared to the I Dream of Jeannie 2.0. I think my sister's going to love that on the pen that I purchased for her, if I can ever get her out of the freaking hospital. Actually, she wants me to bring her some diamond painting. She's got some smaller projects that she can do in the hospital, so I'm gonna go up there today and this afternoon when I visit her and bring her some diamond paintings to work on, the smaller ones. Oh, good. Good, good, good. But, I think I prefer this as to there's a fat one that I have. I think this one's too big. This one's just right, like the 3 bears here. Anyway, yeah. So, I think people need to know that if they're gonna ask for this cut, they need to know it's gonna be on the thinner size. Oh, no, it's okay. I love it. I absolutely love it. I'm just kind of playing around with the different things to find out what I like, Tim. And, it's gorgeous, but, I think compared to this one, I prefer it. So, now that I've got all 3 sizes, I know what I like. But like I said, the other pen I just purchased from you guys, the purple one, that's a gift for my sister. I hope she's not watching. Are you watching in the hospital, Jean? If you are, guess what you're getting for Christmas? I don't think she's watching. Hopefully she's sleeping. Um, where did that Are you talking about this part of it? I like it thin at the base where the baseball bat is. I like it there, like 4.3 at the base, but the middle part where my big hand goes, I like this. That's probably where you got it because the bases are pretty much the same. Um, it's just it gets thinner in the middle, so anyway, I know it's just it's blinding, the sparkles. I do love it. They are still not in the courtroom. I should have known that. It happens every time, and if I don't go live when they say they're gonna be in the courtroom, then sure enough, they'll be in the courtroom, so that's why I just stick with the court schedule. I don't know he's probably making copies of the jury instructions because those go out with the jury. Sarah says, "I'd probably like that cut. I hold my pins in the center of the pen instead of at the bottom." Which cut would you like? The genie one or the I'm actually don't know what this one's called. Um, Tim Tim obviously knows. What's this one called, Tim? It's hard to see because it's so see-through, the pen. I don't know. If I hold it up, does that help? Yes, the finger grips on the end are perfect. Yeah, they're perfect. Oh, you like the thinner ones, Sarah. Yeah. Oh, so while we're waiting for the court sorry, bumping the computer. Don't get dizzy. I'll show you what I got from Diamond Painting Drills in the mail today. Actually, I just got something got delivered just now. I better go see what it is before the porch pirates come. I ordered some of these flame drill things that she has. Tim says, interesting. Maybe I should ask where the people hold their pens most on the end, but there are exceptions. Yeah, that's true. That's true. So these are the, what are these called? Let me get the invoice so I can tell you what these are called. They're all fairy dust drills, except for, well, these are flame drills. Flame drills. So this is the element set. I'm going to take it out of the package so you guys can see it. You're not missing anything. Just they're still on the seal. So I don't know if you can. No, you can't see through there. Ah, hold on. So in the elements set, this one is Earth. And these are the glass drills. They're made out of glass. They're round, but they're round for squares. This is the fire element. This one is the wind element. Oh my God, that's beautiful. And then we have the water element. Ooh, I like that. That's pretty. So that's the element set. Then I have the fall series. I am covering the live closing arguments. They have not started yet. If you're just joining us, just stay tuned. We're going to get to them. You have you love the fame drills. You got the element set. Oh, yeah. This set I really, really liked. Okay, so this one's called Maple Syrup. Oh, can you see those? Wow, they're hard to see. Then we have Fall Leaves. Pumpkin Spice. You're sticking to the and there's so much stuff I could do with this. Apple cider. I don't know who named these, but that's brilliant. These are beautiful. The apple cider. Okay, they're all beautiful. Then I got her monthly package, but I ordered them in packages instead of the little jars. So I got this 740 fairy dust, 720, 349. This is all in that set. It's like a Christmas set. 907, which is going to be perfect for next year because I'm doing Christmas all year long. And if you haven't seen what Diamond Art Club is coming out with this weekend, oh my God, amazing stuff. The 5200 fairy dust. All of the reds are there. Here's the, where'd you go? Where'd you go? Hold on. Here is the 606. So lots of red options, a couple of green options, 701 and oh, green options. There's another one there. And then I ordered more of the 310 for my cat painting, the Halloween painting, because I'm doing a lot of 310 fairy dust. And then I got, where's the other one? Oh, here. The 415 I got as well because I want to do the cat's whiskers in the 415 fairy dust. I think that'll be super cool. Now, where to store them? I'm running out of spots to store all these drills. Yeah, right now I'm just putting them in this pouch until I figure out a way to get all this stuff organized. So a nice little set there. Let me show you what's going on in the courtroom. Nothing yet. So you want to order her 310 and what she offers. I have a painting that is entirely 310 background, and I'm thinking fairy dust 310 versus 310 AB. If the entire, I don't know what the painting is, Sarah, but I would think that if the entire background is 310, what would really be cool is if you take the regular 310 and mix the fairy dust together. That way you get the fairy dust kind of sprinkled throughout that background. That might look pretty cool. Just saying. I wouldn't use a 310 AB. No, I would use the fairy dust 310 and the regular 310 and just mix them all up. Yeah, I think that would be amazing. Really, it would be just a random stuff, you know. So, oh, I didn't put these flame drills anywhere. What am I going to do with these? All right, I guess they'll go in the pouch as well. I also got some more building block sets in the mail. I got to put myself on a no buy. Like, stop purchasing this stuff. I've got so much stuff I could be building all next year. I haven't even finished the pumpkin carriage because I lost one little piece of it. And if you lose a piece, you can't go any further. But what I thought I'd do is borrow a piece from another set until it shows up. What I did the other day was I got down on my hands and knees. I moved everything in this craft room, got down on my hands and knees, searching, couldn't find it. I did find a piece, a building block piece, but it wasn't the one I was looking for. So, unfortunately, people coming and going because there's nothing happening. I know. Okay, those are going to fall out. I'm going to go see what came in the mail today. Oh no, is it any easier to put together? I know it was a struggle in the beginning. Oh no, it's not getting any easier. Any easier. I think because of the roundness of the pumpkin, it's the more you put together, the more secure the blocks are as you're going forward. So it is getting a little easier. But I just finished the last, probably the last difficult part. The rest should be much easier. Getting the finishing touches on it. I just have to like put the roof of the pumpkin on and the wheels and stuff. Yeah. Put the little people together. That's not going to be a big deal. I'm going to put the thing here, put the seal here, and I'm going to see what was delivered on my front porch. I'll be right back. Never mind. I was muted. So what I was talking about is I did do an episode this morning that you might want to check out. I know Sarah's watched it, and I do show in there a couple of videos of that were taken by Sarah Boone that were shown to the jury yesterday. I don't include any of the body cam footage, so I'm sure that's out there. Some other person, Long Crime probably has a video of that out there. The body cam footage was multiple arrests of George Torres, because apparently what was happening is she got at least 2 no contact orders from the court to keep him away from her. And then she would call him up and invite him over to the house. Come on over and watch a movie with me. Come over and have a drink. Come over, let's play darts. And then when he would come over, she would call the police and have him arrested. And craziness, absolute craziness. Oh, hello. Okay, we got the law students are back. I love these 2 girls that are behind him, these 2 female law students. They probably called each other up and said, "What are you going to wear?" Because they're both wearing the exact same thing. These white shirts with the jackets.
We're back on the record. Case number 2020.
Okay, I'm going to mute myself.
State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Ketchcore on behalf of the state. Will J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone. Coming back over.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we work through that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of the 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he/she bracketed still.
I fixed that on page 16.
Then it's just that one, I think that Mr. Henderson and I noticed.
Okay. All right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right. Well,
That's the issue.
all right. Let's face that one. Dude.
Sorry. All right. Thank you. Just give us a minute to fix all this.
Now we have to fix the typos in the jury instructions. I just don't think this jury's going to come back tonight with a verdict. I really think that if they're going to sit back there and
just so that I'm clear, back on the record, we're referring to the bottom of page 12, 3.6G, paragraph 2, where the use is struck through, correct?
Yes, sir.
And then we're referring to the top of page 13 as to that 2 lines as to reputation. Is that correct?
Yes, sir. That should be physical capabilities paragraph or sentence.
Let me pull back up to 3.6G instruction.
if they're going to read through 108 pages of text messages, it's going to take them a while. Plus, they're probably going to want to rewatch those videos. I would want to rewatch those videos from yesterday. At least once. That's why I'm not on the jury.
So that reputation paragraph should be removed in its entirety, and it should be the
Considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
There it is. Thank you. Take it. 10, 12, and 13. Thank you. It is not letting me copy it over, and I don't know why. Correct. Was there anything else other than that? If you find George Torres had a reputation for being violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
The reputation should be believed.
Correct. I agree with you. Yes. I'm sorry. What the heck is going on here?
No reputation, Judge?
That's correct.
What does that state exactly? Is that?
Mr. J, was there another line that we had added to the end of that?
I don't believe so. The physical contact sentence is where it should be.
Okay. Maybe that's what I was maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and George Torres. Is that correct?
Yes, sir.
All right, thank you.
36F.
Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages 25 copies of 12 and 13, and we'll start taking apart our jury instructions and re-adding them. And I thank you for your patience. 12 and 13, that's it.
I do know that George has several family members present in the courtroom today. He has 3 adult children. Some or all of those
Mr. J, are you
children
going
may
to be
be in the
utilizing the
courtroom.
verdict form in closing?
I am not.
Mr. Owens, are you going to be utilizing the verdict form in closing?
I may, where's, is it gonna be at your bench?
Yeah.
I'll ask you for it if I need it.
Very good, sir. Thank you.
Judge, and, when you get a chance.
No, go ahead, sir. I can multitask.
I know there's a mic here.
He's got those poster boards ready for his closing.
I will confirm with
I love it.
court admin that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
And then, Judge, last time I used this fingerprint table as my podium.
That's fine.
I may just slide it back so I'm.
That's fine, sir.
And then, Judge, I've got 2 tripods. And I've got some demonstrative aids. One is this, it was originally a quote by Dr. Michael Brannon.
Objection.
Okay, may proceed. What are the other enlargements, sir?
It's it's the one I tried to get in.
I hear no
an
objection.
Opening, which was the justifiable use of non-deadly force,
No objection.
those 2. And then, you remember my reasonable doubt? I was using it for.
You've seen them?
I
Okay,
had no objection to those 5. I didn't like the 3 charts. The defense agreed that we found reasonable doubt charts they want to use, so I think we're all good on your charts.
all right, very good.
And the only other thing I want to use,
We're good with your demonstrative aids during closings that we were used during trial.
Okay, very good.
I've got 2 videos that I'm gonna wanna play, and Shelby Andrews is gonna walk up.
They're in evidence, right?
They are.
Yep.
Yeah.
Okay,
One of them's been pared down.
that's fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you wanna talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah, I think we both said hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
We're good, let's go.
Say again?
I'm not hearing any,
Okay.
Stammering
The
for
only thing I would
clamoring from the
ask is
state.
after the state has had their first opening, give them a
Agreed.
short break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal. I have received approval from the chief to work after 9 o'clock. So we can go till about 10, maybe a little bit thereafter.
And then you're saying with the jury. And
Correct.
then at 10 o'clock, if we hit some number 10 or 11, then we come back Monday.
That's correct.
So if you are just joining us, we're waiting for the clerk to make corrections to the jury instructions, some typos, then make copies for the jury. Right now there are 12 jurors. 6 of them will be excused and the other 6 will deliberate. I don't know if he does that before or after. I guess he does it after the jury instructions. I don't know where she picked up a 3rd lawyer from, but she's had 3 lawyers there throughout the duration of this trial. So I don't know if one is from the same office as the other 2, or I don't know how that. But I don't know how she could have pulled this off by herself. It would have been a sight to see. So she got very, very lucky to have these lawyers arguing on her behalf to make hay out of not much. She should have took the plea deal. That's all I could say. But we'll see. You never know what a jury's going to do. The jury instructions are voluminous, probably, I think he said 34 pages. So he's going to read those. That'll take a half hour or so. Then we'll get the prosecution's closing argument. Thankfully, they tested the sound system and we'll be able to hear the closing arguments. We couldn't hear the openings. Openings were horrendous. So we're ready when they are. He's really bringing back memories with those poster boards. I remember we would have these huge machines that would print out, they would enlarge and print out whatever you needed, and then you would have to like glue it to the poster board, or you take it to Kinko's and they would do it. Does Kinko's even exist anymore? I don't know. I think we kept them in business until we all learned how to use PowerPoint. This is what's frustrating about being a juror. How is she paying these lawyers? These lawyers are being paid by the state. Once they got on her case, they applied to, I think they call it the JAC. I'm not sure what that stands for, some kind of commission. It's the same entity that pays her experts. Her experts are paid by the state as well. If my recollection, when I was practicing in Florida, which was a long time ago, if you wanted to take on a capital case, you would get $50,000. Now I'm sure it's more than that now, but they get like a flat rate. I don't know what the experts get, but you have to apply and then get approved. But yeah, they're paid by the government. Now, I don't know if the government's paying for 3 lawyers, but they're certainly paying for at least one of them. She doesn't have a lick of money. She spent it all on alcohol. She, at the time of this incident, was living off of the money she made when her and her ex-husband sold their marital home. She got her share of it, and that's what she and George were living off of. And it's a lot of work for that amount of money. I will tell you, they're not making a tremendous amount of money, but I can also tell you that the prosecutors are not making much money either, because when I got out of law school in 96, I was offered a position with the the public defender's office, and they were paying like $28,000 a year. And the prosecution, they make a little bit more, but not much more. Not much. So, I'm sure today it's more than that, but it's not what you would make in a private practice. Just wanted to make sure I wasn't muted. Yep. Anytime you see a capital case, most of the time, well, this is not a capital case. She's not facing the death penalty, but these major cases, whenever you're declared indigent and an attorney has to be appointed to you, they're paid for by the government. In cases like, minor cases like DUIs and assaults and things like that, you're just going to the judge has a list of attorneys who will do these cases. They don't get much money, but they do it
State,
to
are you
get their
ready to proceed?
practices going.
Defense, are you ready to proceed?
Yay, we're
Yes, sir.
ready, finally. And this guy's certainly going to benefit from volunteering to represent Sarah Boone, but he looks like he's ready to
Let's
retire
go ahead and bring in
anyway.
our jury. Bruce. Come on up. I do not. The jury. Okay, thank you.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Everyone can be seated. Thank you. Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and took us a while to print everything out. I'm going to ask the courtroom deputy to come forward and pass these out to you. If you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record will reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. The court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out and to family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find George Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, Murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones. And had exhausted every... Out. Whoever phone is on, get out right now. Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
Judge, I'm missing page 10 and 11.
I am too.
Okay. We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
Mr. Owens, approach, sir. Yes, sir. We'll bring it to you, sir. And we'll wait till have those, sir, and we'll continue. Thank you. Thank you. Record reflect all thumbs were up. Page 11, special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless the threatened, unless one, the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or two, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to: 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10 Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here, on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and the misfortune of doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. Her words, this was laughing and joking and we're all having fun, when she decides that it's going to get a little extra real for George Torres. And it fails on the second count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of second-degree murder. And the law informs us that to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder to be, for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial. But these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven second-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. ING 1062, states 17. Mr. J, may you publish states 17?
Shallow. For everything you've done to me. Shallow. For everything you've done to me. Shallow. Fuck you. Shallow. Fuck you. Shallow. Stupid. Shallow. That's my name. Don't wear it out. I can't fucking breathe, babe. Seriously. Yeah, that's when you do me shaking, Cheryl.
You may continue.
Sarah. Sarah. Sarah, I can't breathe, babe. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. Now you want to give video for it extra. Because I got it. Sarah. Real ransom. Sarah, I can't breathe, babe. Oh. That's what I feel like when you drink on me. Sarah. Fuck you. Breathe, Sarah. Yeah. You should probably shut the fuck up. Shh.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to George Torres's murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. Bless you and all of you too. I'll get rid of him, then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise. He is going to show you this. and this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. But we're still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to stop her. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Roach. Objection overruled.
This is no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense of the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time, she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does is it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brandon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brandon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She will stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She
Especially her. So please, if you can,
dismissed,
dismiss this case.
closed,
Drop it. She is not the type of person.
good person,
Great person.
angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet,
What?
and it could.
Good, I love you, baby. Whatever you want me to say. God will prevail and will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took torturing George Torres to her follow-up video at 11:23 after she had moved the suitcase. Mr. J, you publish from States 17, IMG 1063. It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, we see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone, but only Sarah Boone ever walked out that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Copsall and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt? When she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life. Do you have any doubt? When she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her. Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt. Well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. Do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise for accident.
Wow, that was pretty well done, but I think it answered Tim's questions that, you know, he needed a flow chart.
Y'all may be seated. Thank you.
He just walked us all the way through the verdict
Okay,
form.
may proceed.
Sarah Boone's entitled to a fair trial. I think that right has been compromised here today. I don't know who's scheduled to put the two detectives on the front row with the Torres family, the family of the victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has a right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied. Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
Could the state put the suitcase back in the car?
Yeah, can we clean the well from the state's materials, please? Thank you.
That was interesting. And I don't know what to say about that. Oh my God. So we got 13 minutes until they come back. So I myself am going to take a quick break. So we'll be back on when they get back. I think, yeah. I am looking for something here. Hold on. Yeah, I will be right back. All right, I am back. I think they'll be back in a couple of minutes too. Yeah. I would have hated to have to sit through this trial again. Yeah, they're not getting a mistrial on this. I think that this prosecutor has really very little to do with the victims. They're all handled by a victim advocate. And I can assure you there's a victim advocate present there in the courtroom and that they handled the situation. That family is not even from Orlando. I don't even know if they had any idea this family was going to be there. They're from, I think, Philadelphia. And they were all on court TV this morning. So if you watch court TV, you might want to go check out what they had to say. I didn't find it very insightful. Of course, they love their father, but they did not like Sarah Boone. They said she was very, very manipulative with their father. They could have been his client. Both would be alive and a bit healthier. Yeah, this is true. Very true. They needed, he was taking Badmer something classes, and according to her, she probably should have taken those classes too. She was, the body cam footage of her while she's drunk is really, I don't even know what word to attach to it. She's weird when she's drunk, really weird. Giggly and jumping around and just weird. Both of them are alcoholics, clearly. Or I gotta believe Sarah has sobered up in jail. Hey, Carrie. Hello, welcome. Glad you're here. They should be back any minute now. He was giving him 13 minutes, and it's been 14 minutes. Looks like something's going on in the courtroom there. You caught part of it, Carrie. Probably the most interesting part of it is coming up here. This defense attorney, one of his favorite things to do is stand in front of the camera. So you may be looking at the screen while this is going on and thinking that we don't have video, but it just means you're looking at the back of the defense attorney. I need my sweater. Where did I put it? You're doing your fall fox. I am doing it's called Midnight Whiskers. It's a Dreamer design canvas, and I'm blinging it out, but I think I'm more than halfway done. I don't know if I'm going to get it done by Halloween, but so far more than halfway. Yeah. I work on so many other things, though. It's just ridiculous. I'm, crocheting 2 or 3 things, doing my building blocks.
We are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Kestro on behalf of the state.
William J. for Florida, State of Florida.
James Owens for Sarah Boone.
Kevin Beck on behalf of Sarah Boone. Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends, George Torres may not be in here, and may not be able to hear the instruction, but may come in during the trial, so that we can try to get some order.
Are there any other members of Mr. Torres's family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay. Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel.
They're making their selection.
Okay, thank you. All can be seated. They're making their dinner selections. So we'll just give them a couple minutes to do that. Thank you.
They're busy ordering dinner. Yeah, that is, well, obviously the detective, the lead detective in the white sweater, that's her. Then the 3 kids, the son and 2 daughters of George Torres. I don't know how old the middle daughter is with the glasses, but the younger daughter she was 14 at the time that this occurred. But gosh, his son looks exactly like him. Unless maybe that's his brother. That could be his brother. I don't know where the son lives. I know on Court TV this morning, they had one of his former wives, the mother of those children. She was on. It's interesting that Sarah never shows any emotion. Never. I remember the last case I handled with, I forget her name, the ballerina case. She was sobbing all the time. But this woman she's very stoic. I thought she loved this guy. I don't know. It doesn't show. I agree, Tim. I agree. Well, they talked about her having these narcissistic traits, and that could account for some of what we're seeing. You're probably right. Yeah, I mean, if she loved him, she sure showed it weirdly. Like, let me videotape you while I chastise you and taunt you. Yeah, definitely. And she's probably not getting any help in jail either. She should be. She should get some counseling while she's in jail, but she's probably not. Maybe when she gets to prison and becomes somebody's girlfriend. Counseling will not help. It's not going to change who you are. Okay, this is true. How about, can we hypnotize her? How about that, Tim? How long does it take to order dinner? Come on, jury. 6 of you aren't even going to be there. Not typical counseling. Yeah, well. She's probably going to become the next jailhouse lawyer. I think she definitely has a narcissistic personality disorder. I don't think there's any question about that. I think the person that said she only had 3 of the 9 traits didn't see any of those videos from yesterday. They probably would have found a few more traits there. Oh, I understand. So are people like her not susceptible to hypnosis? Is that what you're saying? She's certainly a victim, but now is creating a world to get narcissistic supply. I have the washing machine going. I hope you guys cannot hear that. I can hear it, but I hope it's not bothering you guys. I'll be muted when he starts his closing argument. So it is 4:30 in the courtroom, Eastern time. So by the time he wraps up, and then we get the state's rebuttal. Wow, it's going to be 5:30, 6 o'clock on the East Coast. So the jury has 3 or 4 hours of deliberation time for tonight. They'll probably get back, start eating dinner, elect a 4-person. I don't know if we're gonna get a verdict tonight. I really don't. If we do, it'll be late, I think. No, her mental health will not allow her to admit she could be wrong. Well, that's true. That's very true. I think, yeah. Now what's going on with the sheriffs? I think it's weird that the lead detective is sitting with the family. That's strange. Is the box? Oh, he put the box away, the suitcase. Wonder if he's going to get it back out. I got to tell you, when I was trying cases, these days were so long. It's so exhausting. Like when your trial is over, you just want to hibernate for like 2 weeks. This is a very stressful process. You're putting in, 12 to 18-hour days as the lawyers. God, can you imagine the train wreck this would have been if she was representing herself? Oh man. It would have been entertaining, but a train wreck nonetheless. It probably would have taken twice as long too. But I have a feeling there are 8 lawyers that are thanking their stars they don't have to deal with this woman. So if you're just tuning in, we are waiting for the jury to order their dinner. They're selecting from the menu apparently, and we've got to wait for them to finish. Then we'll get them back into the courtroom and hear the rest of the closing arguments. This guy, the defense attorney, he's probably rethinking his life choices too. What did I get myself into? Oh my God. Yeah. Bet you'll never do that again. She placed an ad in the jail and he responded to the ad. She placed an ad for an attorney, handwritten ad, and he responded. Crazy. I don't think he's defeated, Sarah. I think he's exhausted. If I'm being honest, he had like a month to get ready for this trial, which is it's pretty remarkable that he's done as well as he has. He'll likely marry her in jail and then write a book. I'll read the book. Oh my goodness. I think yesterday he was downing some Red Bull during his examination of the witnesses. His billing just went up notoriety. Oh yeah, if he stays in practice, yeah. Maybe this is his swan song. He might write a book without her. I think I would. That reminds me, Tim, I'm currently reading a book for our Christmas premiere. The true crime story. That's very different and very interesting. So I'll tell you about it later. What are they having for dinner that they can't decide? I mean, what do you, how long does it take to say pepperoni? No pineapple. Come on. I guess they're not in any hurry. Do you think they get pizza in jail? I don't know. If they don't, that's probably the thing I would miss the most. Pizza.
Okay.
I don't know if that is allowed by the court or.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
I've seen it. It happens.
It's a discretionary issue. I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
I've seen attorneys, even on my channel here, we've seen attorneys split their closing, defense attorneys. It's unusual, but it does happen. The best thing to do probably would just be tell them what you want to say and let the other guy say it. They can't read the time menu. Just close your eyes and pick something. Just tell them what level of spiciness you want. Oh my God, I love Thai food. I haven't had it with my sister in the hospital. I should go find some. Wonder if there's any good Thai restaurants around here. She don't like spicy, so we don't ever eat it, but
Reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
okay. All right, come on. I'm going to look up Thai food while we're waiting. That is a great point, Shelley. Great point. Well, that's, I like that.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members, jury, for one of the last last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Bennett. And we feel confident that we're going to be able to show you why she's not dead. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Providence.
Overruled.
Tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando.
Providence.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it. But I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
We're playing the good old boy card. We're from a small town. So you should believe what we say. Because we're going to say it like this. Who cares? Just get on with it.
Objections overruled.
all I wanted to say is just since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you were the only ones, in this case, because Sarah Bennett was arrested, it's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial and some of the things they said.
Objection. Objection. Can we motion?
Yes. may proceed. Objections overruled.
Thank you, Judge. They've got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Objection, proper argument,
Overruled.
objecting to approach.
Yes.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video, to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life, day in and day out, day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, oh, I'm all right. I'm all right. And so that's why Dr. Harper was talking about the veterans. That's what they'll do. But you got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals, right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. She'd go about 2 days. Texting, calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind, and it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes. Not bad. It was something I wanted to read. Where'd that put it? Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse he endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking, your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception, okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes. But it may turn, by depending on his mood. I don't know if you could tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject. Essentially, okay, I don't know where it's at, but I'm going to have to come back to it. But essentially what it said was, was eventually it's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful, intoxicated, and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase. What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this Vaseline thing. It's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that. Her father's not around. I need to talk about the case a little bit. And if you'll remember, I'll get back to it. If you'll remember, lost my place here. Let's start with the witnesses, and then I'll talk about Sarah. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said, no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from Bader-Spouse syndrome. Wouldn't admit it on direct. Well, maybe I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court. About, well, based on what she told me, I don't think she was in imminent fear. Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. Well, thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
That I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this, make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote. Can't even find it, but it was something to the effect Maybe George Torres is the battered spouse. Can you believe it? Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Objection, proper argument.
Sustained.
What has they done?
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
Let me get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this Abraham Marino knew George Torres from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it's called. The state attorney notifies.
Judge, I'm going to object to reading from things that are not in evidence.
Approach. You may proceed.
So for 4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with the torture. We heard it here. Now, I want to talk to you about the 2 boys that live right next door. You remember Vincent Battaglia and Brandon Motes? Remember those guys? And you remember it came out in the testimony, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel or Detective Copsel up in our case, and she had to say, yeah, I didn't take their 2 statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was, one of them. And, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. You can see it's not disturbed at all. Anyway, I want to get back to Sarah. I want to talk a little bit about that, but let me talk a little bit about the law on justifiable use of force. Is legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres. What did she say? Salt tape. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that, when George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for George. Physically, she's no match. But that's her power, is her words. When she gets a chance, to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him like it is. But she's got that video camera on, and George knows he's being videoed. We've got one that we're going to show you a little bit where he loses it just a little bit. Right again. And of course, we got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape. For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Thorne. She wants him for that moment to feel how she feels. She wants for that moment to feel, for him to feel how she feels, how uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she wanted to give it to him. And if you can imagine,
Approach.
I think from the evidence, you can determine she was crazy about it. She was crazy about it. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others, it's not. There's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. It's all she knows, an old canvas suitcase that she's got some, the two zippers removed or spread out a little bit so he can, so she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know, when they come in from work, what kind of mood they're in. Just by a couple of things, the way you can just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. And she pokes him hard. Trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. Remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining, and it's for support when you walk in it. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute. And, I want to talk about reasonable doubt for a minute. Can't find the page, but I've got one. I've got one up here. Let me find it. If y'all are all looking. I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom 3 short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. You know, reasonable doubt is the highest standard we recognize in litigation. You know, car wreck or something like that is preponderance of the evidence standard, 51%, you're entitled. Abiding conviction, that's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a jury. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt, so I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the highest standard we recognize. If you've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction, it goes on, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jury to decide that. A jury may believe or disbelieve any or all the part of the evidence or the testimony of any witness. I want to show you this before I begin. But Dr. Werner said, this is their expert again. He testified that Sarah Boone suffers from battered spouse syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with George Torres, and there's a bunch, affect their perception. Remember Dr. Brandon, Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George, was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I no more, I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip him to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, or ex-husband, Brian Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually, she walks down. She's looking for George. Where's George? He's quiet down there. And she looks in the bathroom. She looks out. He's smoking a cigarette. Is he on the computer? She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in the suitcase. She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her. I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says, she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. They have told her before, call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? Is she busy trying to hide evidence? Is she busy trying to hide the back? No, she's trying to save his life. If she can. So the police get there. She knows if she told them, she fought back, she's going to be arrested. That's what happened before. What happened before? Like George has said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female that came up here first, the first one that arrived with body cam. Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, man, we're going to arrest you, and she gets a lawyer to go down there to make a statement, and the lawyer would advise her.
Objection, facts not in evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made this statement. She didn't know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but there were some things she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died. That was not intentional. She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect that was going to happen? I've got a daughter that she was about 18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt them up. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat-up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened. I don't want to belabor the point. I do want to show you. Just quickly show you the ending. Sarah Boone got stabbed. Think about that. Stabbed with a steak knife in the leg. And she stayed with him. She stayed with him. Poked between the eyes with a curtain rod. Stalked in the eye. And who does that? The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did. I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways. I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from the veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with you. You know, she talked about, you know, that Sarah uses her words for power. I think her testimony, I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my personal. Okay. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did. And she diagnosed her with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, you know, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He was an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome that you stay trapped in it. I think another big, if you'll think about this, when Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence. Did she emotionally abuse it?
Sustained.
Move strike.
Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, you know. But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You may proceed.
Okay. The prosecutor in opening statement, when he was talking about George Torres passing away, and started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about,
Judge, we would vote.
Yes.
You genuinely don't want to interrupt during a closing argument. It's kind of, it's just not done that much. It's kind of rude. Now, some people do it as a strategy to just sort of throw the person off their game, sort of interrupt their flow, their thinking. Maybe that's what he's doing. But I mean, this guy is personalizing everything, criticizing the government, and it's really been inappropriate. So, sorry, forgot to take it off mute. It is very uncommon for this to happen. Usually everybody's quite courteous during closing arguments, but occasionally it's a strategy to throw the person off their game, to interrupt their flow, their thinking process. But this defense attorney is really making some inappropriate comments. So I can't say as I blame them. I don't know when the last time he did a closing was, but you don't give the jury your opinion on the evidence, or criticize the state the way he does. So, I mean, he's been sustained several times. It is 6:09 p.m. We're in this courtroom right now, and we still haven't heard the state's rebuttal and the judge's final jury instructions. I think it's going to be late when this jury gets back there to start deliberating and have their dinner, and yeah. I don't see a verdict coming tonight. I really do not. They're going to deliberate till 10 p.m. and then come back on Monday. So We we may be waiting for a verdict on Monday in this case. I don't think he's setting up anything for appeal with this defense, except for inappropriate assistance of counsel. But this judge has been very, very careful to ask Sarah at almost every occasion, are you still on board with your defense attorney? Are you still on board with his strategy? And she loves this guy, so.
The violent episodes. It's a bunch of violent nonsense, was his statement to you, an opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether it's that. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah. Okay. Court system got involved. They would have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. Some of the things he said to her. We know about how he treated her dogs nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, was always around her. Part of his fear was her realizing that she'd had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. Judge has been giving court orders all week. I didn't stop George Torres. George Torres knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos. And I want to say something to you. Shelby Andrews is going to help me. If we could dim the light.
Yes.
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a roommate. I dare you.
Did you see him?
Yep, look at him. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it, even though the video was going? Show the next one. Thank you. Thank you, Judge. Can you turn it off? Can you turn it off? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection.
Proper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen. Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma, that you're utilized in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances, and using the force that she used to defend herself. I hope I hadn't missed anything. I've tried my best. Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Thank you, sir. Any rebuttal?
Yes, sir.
You may proceed.
Ladies and gentlemen, George Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, We saw cheating really means women. And a heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this Sarah Boone used force to initially provoke the threatened use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presented to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 May, a movie came out, it's called Star Wars, eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, Another co-employee of this dark posing Vader insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by the law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith,
Oh,
Sarah
no, me
Boone
too.
withdrew from physical
You're gonna
contact
hide?
with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movements. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such neighbor that the act itself indicates a difference in human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to. She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk.
Yep.
She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw all the videos, and I'm not going to belabor it, that we showed in rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiance. Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, that means what it comes across as, she makes the story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply. Won't belabor this since it was discussed earlier. But did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot. But she was so intoxicated that she still felt the effects of it at 1 p.m. the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we, I mean both, with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Approach. May proceed. Objections overruled.
say it loud and clear. Traumatic spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase after he said, I couldn't breathe, she wouldn't let him out. Therefore, all the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is George Torres's head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. That's, you hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened, and then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not
beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. Again, not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both. Members of the jury, I have some additional instructions to read to you. You would be so kind to turn to page 21 of 22. Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven, beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-002603-0, State of Florida plaintiff versus Sarah Boone defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed the foreperson. Final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. The parties approach. Members of our jury, I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110. You successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service. The rest of y'all, if I didn't call your badge, you need to hang out. Thank you. All may be seated. For you 6, you are that will be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then. And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room.
my phone.
You can bring your phone with you. There's a basket that the deputy will take and collect for you. Thank you. Deputy. Y'all can be seated. Thank you very much.
Can I raise something real quickly? Did you intend for the jurors to take the notes into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on their memories.
Any response, state?
That's not the law.
There's a verdict form that there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objection is overruled. Mr. J and or Mr. Cacciatore, do you have the clean laptop for the review by the defense? While we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury? Yes, please.
So at this point, the jury's going to begin their deliberations. I'm going to go ahead and stop the video now because it is 6:08 p.m. Good Lord. Yeah, it's 7 o'clock where they are. So I'm sure the jurors are hungry, as are all of us. I will keep watching. I'll do a verdict watch for the rest of the evening. If they come back with a verdict, I will go live again. I'm going to stop for now. I'm not going to keep the video going. But if they do come back with a verdict, I'll have a separate thumbnail up as a jury verdict watch. And then I'll go live on that thumbnail. Any questions, comments? What's for dinner? How about that? All right, guys. Thanks for watching with me, crafting with me, and listening to this trial with me. I'll see you if we get a verdict tonight. If we don't, then I'll see you later. I'm going to be on Jen's show tonight, DP Addiction Adventures, for our Halloween Craft or Treat 2024. Yeah. Have a great night, guys. Bye.